Recently, we have an increased amount of buyer inquiries into seller non-disclosures. As a result of these increased inquiries, we have also realized that there are some misconceptions concerning what must be disclosed under Florida law. What is the seller disclosure and why does it matter? In Florida, there's a landmark 1985 Florida Supreme Court case called Johnson v. Davis that states that a seller must disclose any latent defect that might have a material impact on the property's value. And while you're not legally obligated to fill out a seller's disclosure, I strongly recommend that you do so to the best of your ability. Note that Florida courts have consistently held that a seller must have actual knowledge of the defect for a buyer to prevail on his Johnson v. Davis claim. This still applies even if the residential property was sold under an as-is contract or had an as-is contract clause. Additionally, if a seller claims ignorance, but it can be proven later on that the seller should have had knowledge, the buyer will have an actual Johnson v. Davis claim against the seller. So what does this mean? Say you forgot to disclose the water tub accident involving little Timmy, where he overflowed the bathtub and the water caused damage to the ceiling below. Even if you painted over the water stains and there was no visible mold, you could still be held liable under a Johnson v. Davis claim. There is also additional requirements for condominiums. If you have upcoming special assessments, you would need to disclose that. Seller disclosure liability can also be imposed on the seller's realtor. Realtors, if you're aware of a property defect or an open permitting issue and you have not disclosed that to the buyers, get it in the seller's disclosure, or you potentially open yourself up to liability and a lawsuit. Please be aware that seller's disclosures do not apply to commercial deals. However, if a seller actively attempts to conceal defects or provide any sort of negligent misrepresentation, the seller is opening himself up to a potential lawsuit. And what is the moral of the story? Disclose, disclose, disclose. It is very difficult to prove a non-disclosure cause of action. For this reason, I strongly suggest a buyer hire a professional and thorough property inspection company to assist them with their closing. Because after post-closing, a lawsuit is nothing but a headache. I'm Michael Schuchat. Have a great day. Don't get sued.